Good morning. My name is Jen Bakley. I'm the Executive Director of the Collection Service Board. It is 9:30 a.m. Central Standard Time, and I would like to call this meeting to order. We will, since we do have members participating via Teams, we will be taking roll call votes. So I would ask that our Administrative Manager, Karen Condon, please take roll.
Chip Hellman,
Present.
Tony Zikovich,
Present.
Lori Hadwin,
Present. Did you hear me?
Yes.
Yes.
Okay.
We have a quorum available and can conduct business of the board this morning. Notice of the October 8th, 2025 meeting of the Collection Service Board, including date, time, and location, has been noticed on the website since July 17th, 2024. Additionally, this month's agenda has been posted on the website since October 1st, 2025. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet in the back of the room or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. All right, and now I believe we need a motion to adopt the agenda for the meeting.
Yes. I'll move that we adopt the meeting agenda.
Thank
We
you.
need a roll call vote on everything, is that right?
We will,
So
yes.
could you call the roll, please?
Do we have a second for that?
Oh, yeah. we
I
need-
second.
That
Thank you,
was
Tony.
Tony?
Yes.
Okay.
Chip Hellman,
Yes.
Tony Zikovich,
Yes.
Lori Hadwin,
Yes.
Thank you.
Okay.
The agenda has been adopted. All right, next we will move to review and approval of the minutes of the July 9th, 2025 meeting of the Collection Service Board. Does anyone have any proposed edits or concerns about the minutes?
Tony or Lori, do you have any concern about the minutes?
No, no
No,
concerns.
Me
Okay.
either.
I move we approve the minutes.
Thank you.
We
I
need a
second.
Lori seconded.
Have a second?
Can you call the roll, please?
Chip Hellman,
Yes.
Tony Zikovich,
Yes.
Lori Hadwin,
Yes.
Thank you. Okay, moving right along. I will give a report on the status of the budget. In your materials on your iPads, you will see a year-end financial statement for the Collection Service Board for fiscal year 2025. Total revenues for the year were $159,510. Total expenditures were $248,101, leaving us for fiscal year 25 in a deficit position of $88,591. At the end of fiscal year 25, the board had a reserve balance of $730,831. And as has been previously communicated, that is considered to be a healthy reserve position, and we will continue probably to see a deficit similar to what we did this year, but we are not at risk of being in an unhealthy position with our reserve. I'm happy to take any questions on that at this time.
Any questions, Tony or Lori?
No questions.
No, Chip.
Okay, me neither.
Okay.
This is a recurring, we've watched our balances gently work their way down because of the change in licensing and so forth, but it's not unexpected.
Okay, that's my understanding as well. All right. Okay, thank you. Moving along, we will now hear a presentation of the legal report for this quarter's meeting.
Good morning, board members. Joe Wharton, legal counsel. On the legal report this morning, we have 18 new cases and then one represent. The case being represented to the board today is based off of the civil penalty recommendation. This case was presented to the board at our last board meeting, and I recommended a civil penalty in the amount of $500 for this surety bond violation. Based off the board's precedent, our previous legal reports, this violation isn't that common, but we've always assessed a penalty of $250. So I wanted to represent that to the board today so that the board could consider, being consistent with the precedent based off that violation and lower that civil penalty amount to reflect what has been done before by the board. I'm more than willing to take any other questions that you have on the cases. After we answer the questions, I can go ahead and read the complaint numbers into the record, and then we move forward.
So is that number 10 and 11 on here, on this report?
The representation is number 19, and
Okay.
there's actually a little heading there that says collection cases represented. It's at the very end. Now, there are multiple cases on this legal report, new ones, where the surety bond has popped up as well. So
Okay.
that's,
So you're suggesting that we stay consistent with what we've done in the past and keep it at 250 every time this happens? And so the one last meeting, we approved 500, you're just wanting to lower that?
to reflect the civil penalty assessed previously.
Good. Does Lori or Tony, do you have any questions? And I know we're going to read these into the minutes here in a second, but did you have any other questions or things you wanted to discuss regarding the legal report?
No, no questions. I can move to adopt if you like.
Do we do that first or after it's read in?
I'll read the complaint numbers in, and then you
Okay.
guys can make the motion.
Okay. Tony, anything?
I have no questions either.
Okay,
No questions.
thank you.
All right, I will now read the complaint numbers from the legal report into the record. Complaint 202-502-9551. 202-502-9881. 202-503-0141. 202-503-0481. 202-503-1151. 202-503-1231. 202-503-5421. 202-503-9081. 202-503-6191. 202-503-7231. 202-504-0721. 202-504-0821. 202-504-0911. 202-504-7191. 202-504-8101. 202-505-0381. 202-504-7631. 202-505-0081. And then 202-502-0861. And then one last note, on the cases where the recommendation has been a consent order, and then a legal case if necessary, if they do not enter the consent order with the board has previously stated their position is that they would want those cases filed in front of an administrative law judge alone to hear the hearing as opposed to being filed in front of the board. I just want to clarify that that is still the board's method of operating moving forward in the cases that are on this legal report. If needed to go to formal trial, be filed in front of the judge alone.
Okay, is there any drawback or reason why that's not a good idea?
I see no drawbacks. It's just, if the board hears the case, it's in your hands. If the judge hears the case, the judge would apply, the law should be applied the same way. So it's the board's choice.
Okay. Tony or Lori, do you have a preference, or should we leave it with the administrative law judge?
No preference. I would leave it with the judge.
I concur.
Okay,
Okay.
that's the guidance. So now, Lori, I'll take the motion, please, to approve the legal report.
I move to approve the legal report.
I
And
second.
Tony seconds. Can we have a roll call? Bub?
Yes, sir. Chip Hellman,
Yes.
Tony Zekovich,
Yes.
Lori Hadwin,
Yes.
Okay, so the legal report's been approved. Do you have an update on the rule?
Our rules went into effect and are now effective as of September 24th. So that rulemaking package we worked on for the last year, it is now in place and official. So
Hot dog.
congratulations to the board.
Yeah, that's great.
Absolutely. That's all I have as far as the rules go. And then I am going to share a PowerPoint from my computer now that goes over public record laws, the Open Meetings Act of Tennessee, and then briefly goes over the North Carolina Board of Dental Examiners versus Federal Trade Commission case. We do this presentation on an annual basis. A lot of this information we go over our new board member orientation meeting, but this is just an annual refresher.
Okay. Let the record show only one person left the room when you said that.
My voice is annoying, I understand. Okay. All right, so this is a presentation on the Open Meetings Act and Public Record Laws of Tennessee. We call it Sunshine because the goal of the Open Meetings Act is to shine light on all the board's activities so that the public is aware of what government action is taking place. This disclaimer just states that the information presented to the board today is on a general nature. It is not a direct legal consultation based off of specific facts of your nature and case. The other statement is laws change and adapt over time. The department has done due diligence to make sure that all the laws presented in this material today are up to date and accurate. However, if there is a mistake, this disclaimer just states that the department is not liable for any errors or omissions, excuse me. Okay, Public Records Act. What is included in public records for a board or commission? These are the documents, papers, letters, maps, and books of official business of the board, media, which would include photographs, microfilms, films, and sound recordings, and electronic data, processing files, and output. What it does not include are your iPads, our projector, the projector screen, the physical items that are used to disseminate the information. Let's go over the Open Meetings Act. The Open Meetings Act, what is it? What is defined as a meeting? What is not defined as a meeting? What is required by the Open Meeting Act? And then what happens if a violation occurs? The General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business and shall not be conducted in secret. This part should not be construed to limit any rights and privileges contained in Article 1, Section 19 of the Constitution of Tennessee. I looked up that constitutional provision. It reads pretty cool, so I'm going to go ahead and read it now. That the printing press will be free to every person to examine the proceedings of the legislature or of any branch or officer of the government, and no law shall ever be made to restrain the right thereof. The Open Meeting Act has a goal to promote openness and accountability in government and to protect the public's interest. Because we are trying to protect the public's interest, it is best that we construe the Open Meeting Act broadly. All meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. Governing body. What is a governing body? The members of any public body which consists of 2 or more members with the authority to make decisions for or recommendations to a public body on policy or administration. The Collection Service Board, as you all have guessed, qualifies as a governing body, and that is why we are going over this information today. It applies to every meeting of the board. What is a meeting? Meeting means the convening of a governing body of a public body for which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. A meeting does not include inspections of licensees, and a meeting does not also include a chance meeting between 2 members of the board or commission. So if you guys were to bump into each other as you're walking around in public, that is not going to fall underneath the Open Meeting Act. However, if you bump into another board meeting, you all are not to discuss official board business. If you do, then it would fall within the definition of a meeting and fall within the purview of the Open Meetings Act. What is not a meeting? Lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, adjournments between days, just simple stuff like that. Open Meeting Act also does not apply to executive sessions. Executive sessions occur when 1 or more members meet with the board's attorney and the board is under lawsuit or has been threatened with suit, and the members ask their attorney questions related to that lawsuit. The board may not deliberate about any specific matter before it or potentially before it at any executive session. The conversations during that session have to be related to the lawsuit at hand. How far does the Open Meetings Act extend? If a member emails the chair, here's a news article that would constitute a meeting. I'd like something included on the next agenda would also constitute a meeting. And then here's a news item about one of our licensees. We should consider revocation. That would not be considered an open meeting because the legal report and complaints would be presented before the board for official discussion at the official meeting. If a member emails the board's attorney, I have a question about the legal consequences of something the board has done, that is going to fall within an open meeting. What wouldn't be is if you asked a legal question about your personal nature. I have taken an action as a commissioner and now someone is upset. That is relating to you as an individual as opposed to the board as an organization. I really want to bring this slide to your attention. If a member emails another board member, if you send an email or pick up the phone to call another board member, that is not a chance meeting. You are doing that deliberately. Even if you don't discuss board business, it gives a strong appearance of impropriety, and for safety's sake, it ought to be avoided. So, please do not contact other board members via email or phone call outside of our board meetings unless it's absolutely necessary and does not relate to board business.
Can we pause there for a second?
Sure.
Because some of us are in the same industry, there are national items that pertain to our industry. So are you saying that, as an example, Greg and I are both in the collection business. If I call Greg not to discuss anything related to Tennessee, but talk to him about something on the national level, maybe the Consumer Financial Protection Bureau, so forth, or what our industry is doing to lobby Congress or something, that would be a violation because I have called him and he's on this board?
The Open Meeting Act is to be construed broadly. I'm not going to say directly that that's a violation, but I would state that we're getting very close. We're not discussing official board business, but you are discussing the industry. So I would try to limit those calls to as few as necessary.
Okay, and then along those same lines, we're likely to have chance encounters at industry events where we both are in attendance. We have to be very careful about that as well, right?
Right, the chance encounter is not as big of an issue because it's not a deliberate act. You both show up somewhere and then you just see each other by chance there. As long as you don't discuss board business, it's fine. Calling or emailing isn't, unilaterally a violation in and of itself. It's just it's a deliberate act between two board members, which kind of raises a higher level of scrutiny to the communications going on. So
Okay.
just because you email another board member, that's not a direct violation. And a chance meeting is given a little more grace because, it's not a deliberate act.
Okay, so this actually happened with Greg and I communicating about a federal matter that we were both working on. Should I have disclosed that prior to now?
I would always recommend that board members disclose anything that they believe to be relevant to the board during our meetings, but, disclosing it now is the best that we can do at this time. So I would just
Okay.
say moving forward, we just try to prevent those communications as much as possible.
Okay, thank you. So therefore, I've just disclosed it. But we never talked about the state of Tennessee or this board.
Right, absolutely.
We strictly were working on an American Collectors Association, ACA International initiative.
Absolutely. Yeah,
Okay.
I don't think that that's wrong. I'm just saying that the Open Meeting Act, as we read earlier, it's construed broadly, so any direct communication between you two could theoretically be reviewed with a higher level of scrutiny, and as long as we didn't discuss direct board business, I don't
Yeah, we
believe it would be a
didn't.
violation. So-
But it's a point.
good to keep
Put
in
an
mind moving
exclamation point on that one bullet. Okay,
Absolutely.
thank you.
The act is to be construed most favorably to the public and is all-encompassing and applies to every meeting of the governing body except where the statute on its face excludes the application. The public has the right to attend, observe, and make comment at your meetings. Public comment is permitted at each meeting and is limited to items listed on the agenda. There's a three-pronged test to determine whether or not notice for a meeting was adequate underneath the law. Those three prongs are reasonably, sufficiently, and posted. Adequate public notice. The contents of the notice must reasonably describe the purpose of the meeting or the proposed action to be taken. Notice must be posted at a time sufficiently in advance of the actual meeting to give citizens an opportunity to become aware of and to attend the meeting. And then finally, notice must be posted in a location where a member of the community would become aware of such notice. There are two usual methods of notice, internet and newspaper. Our board uses our website and the internet. Posting a notice online to meet the adequate public notice requirements is contingent on facts and circumstances beyond the posting and whether the location would be one where the members of the community could become aware of the notice. We post our meeting notices on our board's websites because people in the industry would go directly to the board and expect to see the notice there, so that complies with the act. It is a totality of facts and circumstances test. So if an action were brought underneath the Open Meetings Act about our notice of a meeting, they would look at every fact and circumstances. It's not just simply that notice was posted and we are cleared. They would look at the timeline, how it was posted, what information was contained within it. If a violation of the Open Meetings Act is found, two matters can happen. Any official board business that took place at the meeting that was in violation will be nullified, and then the moving party can seek legal costs and attorney's fees from the board for violating the act. Essentially, the Open Meeting Act is designed to make sure all board business is conducted in a way that's accessible to the public. Remember that it applies to you and to not discuss official board business outside of a board meeting. The only exception to the Open Meetings Act would be the executive session in which the board has been sued and you are seeking legal advice within that meeting. No official board business is discussed. All right, let's go to the North Carolina Board of Dental Examiners versus FTC case. The North Carolina Board of Dental Examiners issued 47 cease and desist orders to non-dentists that were offering teeth whitening services. In response, the FTC filed a complaint alleging that the board violated antitrust laws. The board argued that it was protected from that allegation based off of state action immunity. The case was appealed to the Supreme Court. The Supreme Court rejected the board's state action immunity defense. The board did not receive active supervision by the state when it interpreted the act as addressing teeth whitening and when it enforced that policy, issuing cease and desist letters to non-dentist teeth whiteners. Essentially, the board was acting on its own. They didn't pursue rulemaking. They did not have a formal discussion on the record and just essentially cut these cease and desist letters. And the Supreme Court did not feel like that represented government oversight. What is active state supervision? The inquiry regarding active state supervision is flexible and context dependent. Active supervision need not entail day-to-day involvement in an agency's operations or micromanagement of its every decisions. Rather, the question is whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state policy rather than merely the party's individual interests. Tennessee has enacted a law that puts in place a supervising official who reviews all of our board meetings. Each supervising official shall ensure the actions of regulatory boards that displace competition are consistent with a clearly articulated state policy. Other than rulemaking, the supervising official shall evaluate whether the action may constitute a potentially unreasonable restraint of trade that requires further review. If it is determined that an action requires further review, the supervising official would provide notice to the board within 10 days, review the full evidentiary record regarding the action, and if necessary, supplement the evidentiary record or direct the regulatory board or other involved persons to supplement the evidentiary record, conduct a review of the substance of the action de novo and on its merits, and then finally, in writing, either 1, approve the action of the board, remand the action, or 3, veto the action. That's all I have, so if you guys have any questions on public records.
So the North Carolina case, can you bridge that over and say it in non-legal terms, how that applies to us? And please.
Yeah, absolutely. So essentially in that case, the North Carolina board reviewed complaints and then essentially at the same meeting construed their laws to include teeth whitening, even though their statute did not officially state teeth whitening. And they extended their license protection to a wider range of individuals than the statute provided. There was no official rulemaking, like how we went through rulemaking last year. So we proposed rules. Those rules were proposed in front of the Joint Government Operations Committee of the legislature. There was a rulemaking hearing where the public could comment on them, and the board could take in effect those comments, and then the legislature also reviewed and approved those. So when you go through rulemaking, there's more layers of review. The North Carolina board, they did not pursue rules that stated teeth whitening would be construed as part of their statute. They said, we consider this dentistry, and then they issued those cease and desist letters right away. And so essentially, the takeaway from the Supreme Court's message in that case is when we make formal decisions as a board, motions, and we want to formalize it if necessary in a policy or a SOP, and then essentially publish that with the legislature. There's a little conduit that we publish that, and they review those on an annual basis. I believe we have those turned in by July 1 of each year. So essentially, that supervising official makes sure that our legislature is up to date on any policy that our board adopts.
Okay, and the FTC got involved because they considered it a restraint of trade.
Right. They basically closed down 47 small businesses that were offering teeth whitening services, saying that that constituted dentistry, and technically it did not. So essentially, they were shutting down
Okay.
business.
All right. Joe or Lori, do you have any questions for Joe about what we just learned?
No questions.
All right.
No
Just-
questions.
One last disclosure, see all this stuff's coming out. I had coffee last week with an administrative law judge here. He's just a personal friend. He doesn't even know that I'm on this board. We've never talked about collections. We talk about family and stuff. So that would be something I should be careful about, right?
I would just be careful because a case of this board could be filed in front of them. And obviously, if you all have that personal connection, there's going to be an evaluation on his behalf of whether or not he would need to recuse himself. So
Right,
I'll leave it up to you, but it might be in your best interest to, just let him know you are on this board.
yeah. I kind of thought the other way, that if he didn't know and we never talked about collections, then I haven't influenced him but maybe I should make sure he knows that.
Just because it's a personal relationship and underneath the judge's rules, that may require him to recuse himself. I'm not sure. So
Okay.
that's just the reason why I bring it up.
Okay. Is there any new business that anyone would like to bring forward? Lori or Tony, do you guys have any, like, earth-shaking
No
new
new
business? Okay.
I do not.
Is there anybody who has signed up for public comment?
I don't see any. Karen, do we have anyone online? I don't think so. No. No one has signed in for public comment.
Okay, is there anything else anyone can think of before we adjourn this meeting? Would we like a 5-minute presentation by the lady in the audience on some subject that we give her when she gets to the microphone? Okay. Our next meeting is on January 7th of 2026, hard to believe. And by the way, Jen, could I just ask you, I know we had some training as board members we had to go through. Have all our board members completed the training?
I believe most have. I've got one or two to follow up with.
Don't name names. But,
We are mostly compliant.
okay, that's great. Could I have a motion to adjourn, Tony or Lori?
One quick, do we think that we can continue the virtual meetings for January?
We can have, Joe, let me know if I misspeak, but we can continue to have virtual attendance. I don't actually want to misspeak. Will you recap the change for us?
My suggestion would be, if at all possible, be physically present at the meeting. If there is, a situation or circumstance that prevents you from being physically present, just provide that information to us and we'll allow you to attend virtual. And if after the fact, if there's any question as opposed to, our virtual attendance numbers, we would have like a factual circumstance to point to and justify the virtual attendance. That would be my advice.
Okay, thank you. I would move to adjourn the meeting then.
Okay, I'll second that.
Okay, can we have a roll call?
Roll call, please.
Chip Hellman,
Yes.
Tony Zekovich,
Yes.
Lori Hadwin.
Yes.
Okay, thanks, everyone,